Okay, so as we go through these different scenarios, I'm going to read it out loud, and then I'm going to ask you guys to vote on which way you think it should go. I'm going to read the percentages of who voted for what out loud. Again, I'm not going to single out anybody's name, so don't feel bad if you vote for something wrong. The reason why I tell you the percentages is because these are pretty common scenarios that we're going to be reviewing today. And I want you to see how often, whether you get it right or wrong, how often other people misunderstand it. So it helps you understand the pressure on you as a real estate agent to be the expert, because a lot of times in our transactions we do end up educating the other real estate agent in order to have a smooth transaction. Okay, so it's good for you to know your stuff to avoid problems. So first of all, this one deals with acceptance. Oh, and if you're in another state and laws or rules are different in your state, again, please type in a comment and let me know how things differ there so that I can make adjustments to this for the future. But for the most part, we've done this a couple of times for different states, and everything should apply to you as far as I'm aware. Okay, so the first scenario here, Brad makes an offer to purchase Sue's property. Sue gets the offer and decides to counter it. And she gives Brad until Halloween night at 5 p.m. to accept the counteroffer. Now, Brad doesn't know this, and it's irrelevant whether he does or not, but Sue's aware that there are several other buyers that may be interested in her property. However, Brad, within his deadline, in fact an hour before his deadline is up, he decides he's going to accept the offer. So he signs the purchase contract, it's accepted and everything, and he must live right there in Sue's neighborhood because he decides he's going to walk over and hand her the signed contract. That's how he's choosing to deliver it. Now, folks, these situations are a little bit contrived, but they're done so on purpose to really illustrate a point, okay? They basically make the situation almost a little bit ridiculous, because in that ridiculousness, it drives home a point that you need to understand, okay? So anyways, it's a little bit contrived, but bear with me on it. So Sue's sitting in her front room. She sees through her window Brad walking up the driveway. Now, Brad doesn't know this yet, but Sue has been feeling around with some of these other buyers, and she thinks that she can get a better offer. So Brad rings the doorbell, and Sue yells through the screen door, "I revoke my counteroffer." But Brad replies, "But I've already accepted it. It's signed and everything. Here's your signed contract." The question is, do we have a signed contract here? Brad's already signed it. He's within his deadlines, but Sue yelled through the door that she had revoked it. So if you think that we have a signed contract, click the little button to raise your hand. And again, for those of you that are new to this, on your webinar dashboard panel, there's a little button that looks like a hand, and I would love to get everybody's participation. So if you think that we have a signed contract here, click the little button to raise your hand. Okay, I'm going to lower the hands. Oh, letting people still vote. Lower the hands now. And if you do not think we have a signed contract, raise your hand. And I'm just doing this to see how many people are actually participating. Okay? And I would love for everybody to participate. You know, give it your best guess. Okay. Of those that are participating, which is about 2/3 of you, we have an equal split. 1/3 of you say yes, we have a contract. 1/3 of you say no. Now, this drives home my illustration that I mentioned to you earlier. We've got a dead split here. Now, there is a right and a wrong to pretty much all of our purchase contract questions, but in this case, half of you are falling on different sides of the fence. So easily you can see how we can get into disputes as real estate agents. Hopefully this training today will help resolve some of those disputes. I'm going to lower all the hands, and let's look at the answer here. Okay, the answer is no, we probably don't have a legitimate contract here. Now, they actually quote some legal precedents here. So the interesting legal question they talk about is, can an offeror, Sue in this case, revoke an offer prior to Brad's valid acceptance when the interval between the revocation and the attempted acceptance is very brief? And the answer is yes. At any time prior to acceptance, the offeror can withdraw or revoke their offer. By doing this, they terminate the offeree's power to accept that offer. So in this legal precedent here, they actually say this scenario: if you see them approaching and you know that acceptance is contemplated, if you can shout out that you revoke your offer before they actually accept, doesn't matter how brief the interval, then it's revoked. Now remember here that in order for you to have acceptance, your contract specifies two things must happen. The clients have to sign it and you have to communicate it to the other party. In this case, even though it was signed as accepted, Brad had not yet communicated it to Sue, and before he could communicate it, it was revoked. Therefore, we do not have a legal acceptance here. Okay, I've got a great comment typed in here. It says, so the revocation doesn't have to be in writing? And legally, no, it doesn't. However, because, as we've seen, half of you completely disagreed with the other half, the likelihood for complaints to be made or people going to their brokers and complaining about it and having brokers fight with each other, or maybe this landing in a board mediation or something like that, that likelihood tends to be very high when it's a he said, she said thing. So even though legally it does not have to be in writing, technically, and we've got this risk reduction tip down here, to avoid any potential legal problems, if you do wish to revoke an offer or counteroffer, it's best to be done in writing. However, the law does not require that. It just means that you could sue each other and say, you know, Brad could say, oh, no, she didn't. I did say it first. And then you're in a he said, she said. And for some of you guys, you may be sitting there thinking, well, it's totally irrelevant. It could be accepted, and they're within some deadlines, and so, you know, it's easy enough to get out of. That's not the question, though. The question and the things that I want to drive home here is, first of all, let me go back here and let's look at this scenario again. Okay, first thing that I want you to understand as real estate agents, because this is very commonly misunderstood, is that even though Brad has until 5 p.m., and even though he gets his counteroffer in early, 1 hour, a lot of agents think that Sue cannot entertain other offers because Brad was first in line. That is not how it happens. And so in your fiduciary duty to your clients, and you guys may have learned this if you've taken the required Code of Ethics course that the National Association of Realtors is requiring of all of us this year, but it actually talked about this in that course, that we have a duty to treat all parties honestly, but it doesn't mean that we have to be fair. And that means that even though Brad was first in line with his offer, if Sue gets another offer after that, or she thinks she's going to get another offer after that, if it's in her client's best interest, then Sue can accept that one before she considers Brad's offer, even though Brad was first in line. Okay? The other key point that you need, so let me finish up the first key point here, is Brad, even though he has until 5 p.m., he should not use that whole deadline if he doesn't absolutely have to. If he can get with his client and get a response earlier than that, he should immediately do so, because that's in his client's best interest, okay, is to get that property tied up for his client as soon as possible. So don't sit on your laurels because you have until 5 p.m. If you can get it done sooner, definitely do so. All right, so that's the other good point that we learned from this scenario. And then, yes, if you have a chance to get it in writing, that's always best. All right, how should a seller manage multiple offers? By the way, I want to mention that even though these situations may seem contrived to you, in almost every case of the situations we're going to go over today, I've had personal experience as a broker with my agents getting in trouble for some of these situations, okay? So this is one of those. Buyer number one makes an offer to purchase the seller's property. So seller counters offer to buyer number one with an increased purchase price. So far, this is pretty normal, happens all the time. Now buyer number two comes along and they make a great offer to the seller for the same property. The seller wishes to accept buyer number two's offer and does so by signing the contract and communicating their acceptance to buyer number two. Minutes after the seller communicates their acceptance to buyer number two, buyer number one faxes to seller their signed acceptance of the seller's initial counteroffer. Now both buyer number one and number two feel like they have a contract with the seller. Question for you is, who has the valid contract? Is it buyer number one, because they were in first position, they were countered, they accepted it, So buyer number one has a valid offer. If you think that they have the valid contract, click the button to raise your hand. Okay. If you think that buyer number two has the valid contract, click the little button to raise your hand. Okay, hopefully we've got everybody's vote in. And just as an FYI, only half of you voted this time. So again, please, if you're not voting, give it your best guess. Half of you voted and all of you voted for buyer number two. Now, this might surprise some of you with the answer here. It's not really a trick question, but the answer is definitely tricky. Who has the valid contract? Actually, they both do. And you might be thinking, but wait a second, I remember from real estate school that both parties, and actually one of you did take the time to type in, I would think they both do. So congratulations to you, you got it right. So you remember from real estate school that both, obviously a seller can't have two contracts. They can't sell the home twice. So did something illegal happen? No, not really. They just didn't do their paperwork correctly. So let's go back and look at this scenario. According to the terms of the purchase contract, did buyer number one legally accept the offer? They were counter-offered. That's just fine. So everything's good there. They, if we skip this little interim here, before the offer was ever revoked to them or the counter-offer was revoked, like we saw in that first situation, they signed acceptance and faxed it over and communicated it. So according to the terms of the contract, buyer number one legally has an accepted contract. Now, so does buyer number two, because it was signed and communicated and accepted. What this does is this puts the seller in a very difficult position. Now they have to cancel one of the contracts because obviously they can't sell it twice. And in the contract it outlines the prescribed penalty for doing so. Now when this happened to my agent, because my agent was fairly new in the business and didn't realize that there was a multiple offer form, so he countered both offers, and both offers signed acceptance and sent it back to him. Now, they actually signed acceptance hours apart. In this scenario, it was minutes apart. And I just want you to know that the time is irrelevant. They both accepted, in my personal scenario with my agent, both offers were accepted within the deadline, and so even though they were hours apart, they both had a legally accepted offer. Now this one involved attorneys. Both buyers contacted attorneys. I contacted the state's attorney. And so we spent a little bit of time on this one. The thing that we can learn from this is if you're a listing agent, number one, make sure you know your forms. If you're getting multiple offers, make sure you use the multiple offer disclosure form because that does protect you from situations like this. Number two, if for some reason, because in this case buyer number one came in first and then buyer number two made a better offer, if that happened, remember you need to call immediately and revoke your counteroffer with buyer number one because you've accepted buyer number two's offer. And by revoking that, it removes the power of buyer number one to sign acceptance. All right? Okay, I've got a good question in here. What happens when you have a short sale and you receive multiple offers, but the seller has not signed any? Okay, and this is unfortunately, short sales really complicate everything, and I'm not sure if different states have different laws regarding short sales, but in the short sale addendum, if you pull that out, it almost complicates things a little bit further, because what it says, what happens when you have, let's answer this question first. You receive multiple offers, but the seller hasn't signed any. Again, it's about what's best for your client, so it doesn't matter which offer comes in first. Typically with a short sale, your seller only accepts one offer and then sends that into the bank. If you send in a whole bunch to the bank, usually the bank just keeps restarting the process over and over, and before you know it, your client's gone into foreclosure because of how many times it's been reset, and it's a lengthy process already. So typically a listing agent only sends one offer in at a time to the bank. So the seller would pick the best offer, either highest price or one they think has the best chance of closing or whatever, and let the others know that they could be in a backup position or something like that. If you use the short sale addendum, that complicates matters further by saying that until you have third-party approval, you can continue to entertain other offers. So you don't really have anything firmly tied up as a buyer, because anytime prior to that third-party approval, somebody else could sneak in, and if the listing agent wanted to, they could probably submit that offer to the bank, and you could be out. But again, make sure that you understand your contracts, and especially if you're in a different state, get in there and read that short sale addendum, because that that really changes things. Okay, it mixes things up a little bit, which is one of the reasons that on short sales, equity requires that short sale disclosure form as well for your clients, because they are so complicated and it's easy to get complaints. So great question. All right, let's move on to our next scenario here. Who must sign the purchase contract for it to be valid against the sellers? Now this one I actually had happen, I think last week, with one of my agents. And it was actually with another equity agent, so we've got a good chance of one of them maybe being on here. It was a limited agency, not in the same branch. One was in my branch, one was in another office, but they had this problem with each other. Lisa's the listing agent on the property. She takes the listing and begins marketing the property. An offer is presented and is accepted by Sue Yu, the seller. 2 days after the property goes under contract, a backup offer is presented which would net an additional $10,000 for the seller. Sue, the seller, wants obviously to accept the backup offer. It's 10 grand more in her pocket, and she wants to cancel the first contract. Lisa, the listing agent, informs Sue she doesn't have the right to simply cancel the first contract. You know, contracts are there to protect both parties. And Sue responds with a zinger. She says, "My husband has never signed the listing or the purchase contract." So the question for you guys, is the purchase contract enforceable against Sue's husband? Sue has signed, she signed the listing agreement, and she has signed acceptance on that contract, but her husband has not. So is this contract enforceable? That's the question. If you think yes it is, click the button and raise your hand. Okay, I'll lower the hands. If you think no it is not, click the button and raise your hand. Okay, and I'm very impressed with one of you. You have raised the one question that really clarifies this, and it says if the husband is on title, then no. So very good. That is the one question that remains to be answered before you can correctly answer this scenario, and the question is the husband on title? So let's look at the answer here. The purchase contract is not enforceable against Sue's husband if the property was owned by Sue and her husband as joint tenants. Now, most of our situations are that way, so most of you got this answer correct, making the assumption that Sue and her husband were joint tenants on the property. If they weren't, and only Sue was on the property, maybe she was the only one that had a job, or her husband had bad credit, so she was on the loan and the only one on title, and they'd never gotten both put on for some reason, then it would be enforceable against Sue because her husband wasn't on the property. But if they're both on there as joint tenants, that purchase contract and the listing agreement are not enforceable. Okay? In order for all title owners of a piece of property to be contractually bound, they've all got to sign and accept the purchase contract. If Sue's husband's signature could not be obtained, she might consider getting written authorization from her husband to sign the contract on his behalf, like a limited power of attorney. All right? But without that authorization, Sue cannot bind her husband to the contract, and you have an unenforceable contract. In order to avoid this situation, agents should simply look at the title report to see who owns the property. Now, in our situation, the hairy thing about it is the listing agent was told by the seller that their client had a quitclaim deed removing his spouse from the property. However, when it came down to it, he did not have that quitclaim. And it was, so he didn't have it, it couldn't be filed. It was a divorce situation, which we run into this type of thing a lot with divorce situations, is that there's only one person living there, they've split up, but title is still in both of their names. So this can actually be a very common scenario because unfortunately divorce is kind of a common occurrence out there. And FYI, I'm not picking on anybody. If you've been divorced, so have I. So I understand and empathize with you. Just understand when you go into a listing situation with your clients, be aware that you need to check the title report first. Now, who is protected and who's at fault? This is where we had a problem in our situation, and luckily the seller felt very bad about this, and he wanted to pay the agent because the agent had done a lot of work. So he offered to pay the agent enough that the agent could then pass along some of the payment, because the buyers had already done inspections and appraisals. They were ready to close, and they couldn't close because they never had the wife, her signature on any of the contract, so it wasn't enforceable. So this was diffused by the seller volunteering some money. However, and again, we didn't take this one to an attorney, but I believe if it had gone to an attorney and had gone to a dispute, because the purchase contract was not enforceable, then the seller didn't have to pay any fees. So how can the buyer protect themselves? Well, the buyer should have checked the title report. This is one of the parts of seller's disclosures. If you'll look in the disclosures that are required by the purchase contract, one of those is a copy of the title report. Now, most agents don't provide that. They'll provide the seller property condition disclosure form, but they don't provide the title report, and that is a required part of the seller's disclosures. So pay closer attention to that if you're the listing agent. Make sure you provide all of that documentation. And if you're the buyer's agent, make sure that you open that up and make sure that you've got a legal contract with the people that are actually on title. I had this happen with another one of my agents probably 10 years ago, and they worked for 5 or 6 months for free for the sellers because unbeknownst to them, although it was an adult couple that owned it, it was their, or that had signed the listing agreement, it was actually their parents that owned the home. And so nothing that that agent did was valid because he didn't have a valid listing agreement. He had signed it with people that weren't owners of the property. So be aware of this, and to alleviate some of your risk and time lost as listing agents, check that title report as soon as possible. If you can't do it before you actually go out and list with the people or meet for your initial listing presentation. Okay? All right, let's move on. Now, this is a common one. What if there's a conflict between what's written in the MLS and what's written in the purchase contract regarding items included in the sale? The agent's listing on the MLS states that a hot tub is included as part of the sale. I've got a comment in here I need to read. Okay, any questions? This is a good comment. Any suggestion on what to do when seller's agents don't provide the proper disclosures even after being asked? This is a tough one. Now, if we're talking about the title report, then that's something that we can have our own title company typically do the research on and provide for us. So if they don't provide it to us, we can do that research ourselves to protect our clients, and we can get that information usually fairly quickly. If they don't provide it, then you're faced with a difficult situation. And what I always recommend in difficult situations is it's usually not your choice how to proceed. What you do need to do is take it to your clients and tell your client, look, I've asked them multiple times for these disclosures. We're supposed to receive these disclosures from them by this deadline, and they failed to provide them for us. That gives you several options. You can continue with the contract, and do a really detailed inspection. I'm not sure why they wouldn't provide us with disclosures. So, if they are trying to hide something, let's make sure we have a great inspection. Or you have the opportunity to back out of the contract based on them failing to perform the terms of the contract. And so, in other words, I would educate your client how the contract reads and what options that gives them, and let the client choose how to proceed. Okay? All right. Now, let's go ahead and read this scenario right here. So the agent's listing on the MLS states that a hot tub is included as part of the sale. The buyer enters into a purchase contract. By the way, REPC is Utah's shorthand for real estate purchase contract. I know other states don't use that term. But buyer enters into a purchase contract with the seller for the property, and during the evaluations and inspections period, they notice that there is no hot tub. The purchase contract does not mention a hot tub. They never wrote that in there, although it was listed as included in the MLS. So the buyer feels like they should be getting a hot tub. The seller says, no, you don't get one. So who is right? Should the buyer get a hot tub, or is the seller right and Nope, sorry, it's not in the purchase contract. You don't get it. Who cares what we advertised? If you're voting for the buyer that they should get one because of maybe truth in advertising rules or something like that, click the button and raise your hand. Okay, I'm going to lower the hands. And if you think that they should not get one, then you think the seller is right. They don't get one. It wasn't in the purchase contract. Click the button and raise your hand. Okay, we've got over half of you saying that the seller is correct. I'm going to go ahead and lower the hands. Some of you even typed in. Actually, we had good comments in here. Let me read all of them. If it's not an inclusion, then it's not part of the deal. In other words, if it hasn't been written in there, it isn't. Another one says the buyer's agent should have made sure that was in the original purchase contract and put in the counteroffer before accepted. Accurate. Another one, if the buyer wanted the hot tub, the buyer's agent should have written that up on a separate bill of sale. If the listing agent put it on the MLS, they should get it, but not legally. Let's see, that's a different comment. Let's see. If the listing agent put it on the MLS, they should get it, but not legally. I'm not sure I understand that comment. Let me go ahead and let's look at the answer here. The answer is the seller is correct. If there's a conflict between the purchase contract and the MLS as to what's included, the purchase contract will likely control. The purchase contract is the legal document that controls the terms of the sale between the buyers and the sellers. Buyer's agents, as you guys mentioned, they should verify that the information that's stated on the MLS is accurate, but don't take the lazy route and just assume that it is. If you want something included, make sure that you write it in there. All right. Now, some of you guys are thinking, but what about truth in advertising laws? You know, isn't there any penalty for the seller here for basically lying in their advertising? And the fact is, there may not be a penalty for the seller because buyer and seller have a contract, and that's what controls here. However, there may be a penalty for the agent because the agent has a fiduciary duty to their client to make sure that what they're advertising is accurate. And if they are advertising inaccuracies, they could be in trouble. So although the buyer does not get their hot tub in this case, the listing agent could still get in trouble and possibly get some fines from the Division of Real Estate for false advertising. So if you're the listing agent, you do have a responsibility to make sure that your advertising is correct. If you're the buyer's agent, make sure that what you've got in the purchase contract is what you expect to receive. Don't just expect something. Another shortcut that I sometimes see agents make, it used to be very common, it's not so much anymore, but agents used to write in there as to what was included, they would write as per MLS. And I would recommend you do not do that because the MLS can change. For example, if I'm a shifty listing agent and I see a buyer agent write in as per MLS, there's nothing that stops me from going into the MLS and changing things. And then as per MLS just changed. According to the state's attorney, if you like to write in as per MLS, then you would actually need to print out a copy of the MLS listing and attach it to the purchase contract, and then you would write as per MLS see Exhibit A, and you would write Exhibit A on the top of that listing agreement. Now, I don't recommend this either because there's a lot of stuff in that MLS that nobody's really verified. Nobody went out and measured the lot. They didn't measure the home exactly. You know, we're relying on appraisers to give us that information, and so I think that's dangerous to write that in there because it could open up a can of worms. So just if you're going to do something like this, just write in the contract what's included and what is not. All right, this one you'll probably all get right, I'm hoping. When a seller enters into a purchase contract to sell real property to a buyer and the property is sold in as-is condition, does the seller still have to fill out a seller property condition disclosure form? If you think yes, they do, click the button and raise your hand. Okay, I'll lower the hands. If you think no, they do not, it's sold in as-is condition, we don't have to provide disclosures, then click the button and raise your hand. Okay, and I've got a typed in comment. Okay, the comment says yes unless it's a HUD home. All right, so let's talk about this situation here. Now, In Utah, interestingly enough, this went to court so often that they changed the entire purchase contract. We no longer have warranted properties. Every property sold is sold in as-is condition. And so that should answer the question for you right there. Should the seller still fill out the property condition disclosure form? Well, absolutely. If every single property is sold in as-is condition, they certainly haven't done away with this requirement for every single property, so every property needs a seller property condition disclosure form. The only time that it does not require a seller property condition disclosure form is as one of you typed in. If it's a HUD home or a bank-owned home, then the seller has no knowledge, and they'll put that in their own contract because HUD has their own contracts, banks typically have their own contract. They'll put it in their own language saying, we don't know anything about the property, and there you go. That's your seller property condition disclosures. We know nothing. However, if you're dealing with investors like people that buy homes and flip them, they're remodeling a little bit, and they say, you know what, we've never lived in the home, and so therefore we're not going to provide disclosures, that is not legal. According to the law, and I believe this is federal, so it should not differ by state, sellers are required to disclose what they know about the property. It doesn't matter whether they've lived in it or not. And in most cases, somebody that's gone in and remodeled a property actually has a lot of information about it. They may know things about that property that people that have lived there for 20 years don't know. Because once you start tearing into walls and doing remodels, you tend to learn things. Also, if you're a landlord, you've never owned the property, well, you've had tenants call in and say, hey, we've got a water leak. Well, now you know something about the property. It's had a water leak. Legally, you're obligated to disclose those things. So make sure you advise your seller's property on what they have to provide. All right. This one is interesting, okay? And I'm going to spend a little bit of time on this one. The listing agent has discovered that a suicide had occurred on the property that he has listed. He has not disclosed this fact to the buyers. Now, by the way, I believe so far from all the comments I've gotten back from other states that the laws are the same, okay? So is the agent required under your state's law to disclose this fact? Remember, this is the listing agent. I've got to lower all the hands here to make sure that we're all on the same page while we start this question. The listing agent knows that a suicide had occurred. Does he have to disclose this fact? Is this a material fact that needs to be disclosed? If you think yes, click the button and raise your hand. Okay, I'm going to lower the hands. And about 12% of you answered yes. Let me change this again a little bit. What if it wasn't a suicide? What if it was a murder? Okay, that's a little bit, I don't know, maybe that changes things in your mind. It's a favorite cable television show is these ghost hunters, and people are concerned about that kind of thing. Is my house going to be haunted? So as a listing agent, there was a murder that occurred on the property. You found out about it. Do you need to disclose this is this a material fact that needs to be disclosed to the buyers? If you think yes, click the button and raise your hand. Okay, again, some hands go up. Actually, not as much as if it were a suicide. All right, next scenario. The listing agent discovers that a previous occupant of the home, maybe even their client, had an infectious disease such as AIDS. All right, and they've of course been living in the home, and and maybe AIDS isn't an infectious disease by definition, I don't know, but let's say that they had AIDS, okay? The listing agent discovered this. Does he have to disclose this fact to the buyers? Is this a material fact? If you think yes, raise your hand. Okay, again, just a couple hands going up. And my last question, trickiest of all, let's say that the listing agent discovers that this property used to be a meth lab. Okay, they were actively cooking meth in this property. It has since been cleaned up, certified as decontaminated by the state, but it did used to be a meth lab. Does this need to be disclosed? Is this a material fact that the listing agent needs to disclose to the buyers? If you think yes, click the button and raise your hand. Okay, a lot more hands went up on that one, and we got an interesting comment that will be good to ask here, okay, or that will be good to add to our discussion. Now, this is a tough one, guys, and I've seen brokers get in fights. You know, brokers, 20 years experience, get in fights over this kind of thing. But there is a right and a wrong answer. If you live in another state, I'll give you the definite answer for Utah. But if you live in another state, you need to talk to your broker about this and make sure that your laws are the same. Okay? All of the answers are the same for every scenario that I gave you. And the answer is no. It is not a material fact on any of those items, and they do not need to be disclosed. Now, again, quite a few hands went up on that meth thing. So let's talk about that in particular. But first, let's read the answer here. And then I've got one of the comments that I wanted to discuss as well. So under a specific Utah code, it's called the Stigmatized Property Statute, the word stigmatized includes homicide, suicide, any other felony, previous occupant with HIV or any other infectious disease. And then if you jump down here part way, it says this year, but it was a couple years old, the statute was amended to also include property that has been decontaminated from illegal drug operations, in other words, meth labs. In other words, if the property has been certified as decontaminated, then disclosure of this fact is not required. So let's look at what the actual law says. The failure of an owner of real property or his agent to disclose that the property being offered for sale is stigmatized is not a material fact that must be disclosed in the transaction of real property. Now, this was such a dramatic law that they actually changed the seller property condition disclosure form to reflect this law, to coincide with the new legislation. So, for example, with the meth question, it now asks, to your knowledge, is the property currently contaminated from the storing or manufacturing of meth? If the property was once used to store or manufacture meth and has since been certified as decontaminated, now again, that certification comes from the state. It can't just be your client saying, yep, we did it. You got to have a certification from the state. Then the answer is no. The property is not currently contaminated with meth. All right? Now, let's go over some of the big arguments that get people upset about this. One of the biggest ones is the buyers are going to find out about it, and they probably will. They'll move into the house, they'll go over and talk with the neighbors, and the neighbor's like, wow, I hope you got a good deal on that because those guys were busted for drugs. They were cooking meth in there. And the buyers are like, what the? How come nobody told me this? And they've just moved all their little kids in, and now they're scared. You bet. They're going to file some complaints, try to sue people, things like that. And so one of the arguments for people disclosing this is saying they're going to find out eventually, to save some lawsuits or whatever, you should tell them. All right? Now, that's a valid argument, but that isn't the question. The question is, should the agent disclose it? And the answer is no. Okay? There is no wiggle room in this. If, for example, let me paint a scenario for you. If, for example, I'm the listing agent and I voluntarily disclose this information. Let's say that my client put $60,000 into this home. He bought a meth lab. He's gone through and done extensive repairs to get it cleaned up. He's done the neighborhood a service, right, because he's cleaned up a meth home. He's taken on some considerable risk in buying a meth home in the first place, and there's a considerable financial investment that he's put into it to get it cleaned up. And I go ahead, breaking the law, and voluntarily furnish this information to the buyers because I feel like it's my moral obligation to do so. Again, I have broken the law by definition of the law. It doesn't matter what your moral stance on the question is. According to the law, you've broken it. How much liability do you think you have as an agent? You've clearly violated the law. You've disclosed confidential information about your client that has actively harmed your client financially. I think you've got some significant liability there. So be very, very careful of this. And if you feel very strongly about this, like we really need to tell the buyers what they're getting into, then talk with your client. But that's not your decision. You can tell the client, you know what, they may sue us. They probably won't win because there's a law that protects you from this. You know, you don't have to disclose it. You've certified it as decontaminated. If they sued you, they'd probably lose. But you may want to talk to legal counsel or something just to make sure. But I can't disclose this. You may want to, however. That's your client's choice, not your choice. Be very, very aware of that, because this is one of the biggest liability questions, and it's one of the highest ones that people feel strongly about against the law, that they should be disclosing this. Okay, so be aware of it. I've got one of the comments that an agent typed in that says, only if the buyer's agent asks. Now this one comes up most every scenario or class that I teach on this, and it needs to be brought up. What if the buyer's agent comes to me and asks me directly, he says, didn't this property used to be a meth lab? Now the question is, how do I answer that? I'm the listing agent. He's asked me a direct question. According to the Code of Ethics, I can't lie. I can't say to him, nope, it did not used to be a meth lab. Okay? Because that would be a lie, and I shouldn't be doing that. So how do I answer? Some of you guys are typing in as we speak saying, tell him. He's asked you a direct question, you got to tell him. Let me phrase it this way. What if the buyer's agent comes up to me and says, what is the rock bottom dollar that your client will go on this house? He's asked me a direct question. Do I have to answer him? Do I have to tell him the truth and say the rock bottom answer is, or the rock bottom number that he'll take is $154,700? Obviously not. Okay, so hopefully that clears up that question in your mind when I put it in that term. Just because the buyer's agent asked me a direct question, I can't tell him that answer. And so it would be the same answer for this. Didn't this home used to be a meth lab? My answer is, actually, I can't disclose that. Do your due diligence. Okay? And if they come back and say, it did used to be a meth lab, it did. And I say, yeah, but it's been certified as decontaminated. Okay, but even if they ask me a direct question, I cannot violate my client's fiduciary duty. Okay, so hopefully that clears it up. And but that's a good one for us to be aware of, because this one is always misunderstood. All right. Buyer and seller enter into a valid and enforceable contract. This comes up all the time, guys. After the purchase contract is signed, the buyer decides that they want to change one of the contract deadlines. Now this, almost every instance this happens. We need to extend our settlement deadline. We need to extend our finance deadline. Okay, whatever. They want to extend one of their deadlines. So they write up an addendum with the modified deadline and they send it over to the seller. Seller reads the addendum and says, nope, and checks rejection and sends it back to him. The buyer learns of this and they're outraged. And they're like, what are you doing? Are you crazy? You signed rejection. This nullifies the whole contract. Is the buyer's statement to the seller legally correct? The seller checked rejection and signed it. Does that nullify the whole contract? If you think yes, it does, click the button and raise your hand. Okay. If you think no, it does not, click the button and raise your hand. Wow, great work, guys. Everybody got this one correct. The answer is no. Again, remember that we had a valid and enforceable contract already. We weren't in the process of offer and counteroffer prior to acceptance. If at any point prior to acceptance somebody had signed rejection, then that would have rejected everything. But in this scenario, we had an accepted contract. Later on, somebody tried to add something to that. So if either party tries to unilaterally add to, modify, or delete a provision in the contract, both parties have to agree in writing, or that addition or modification or deletion does not become a part of the contract, but the contract itself still remains intact. The original terms of the purchase contract still stand. The addendum with the proposed change simply does not become a part of it, and there you go. So the buyer was wrong, and you guys were all correct in your answers. All right, here's one right here, and I'm going to read this through, and I'm not even going to ask you guys to vote on this one. Just a friendly reminder, I guess. During the negotiating stage of the purchase contract between the buyer and the seller's agent, who's been around a long time, decides to handwrite the following language into a counteroffer that will be submitted to the buyer. This contract is subject to the 72-hour kick-out clause. The seller's agent felt that this language is simply a shorthand way to incorporate the language of the option to keep house on market time clause addendum. Are there any problems with doing this? And the obvious answer is yes. Now, I see this done with two types of agents. Brand new agents that don't know that the option to keep house on market time clause addendum exists, and so they're just making stuff up, or experienced agents that are so familiar with all the contracts that they're writing shorthand, okay? Just abbreviating things because they figure everybody knows this stuff. Either way, they're wrong. So there's potentially serious problems with this. First of all, if you're drafting language yourself, it could be considered the unauthorized practice of law. We are not authorized with our real estate license to go and create contracts or to create legal language. So if we've done that, it could be the unauthorized practice of law, and you could actually get in trouble with the Division of Real Estate. Second of all, and this is the major problem that actually lands you in front of the Division of Real Estate, is when you make up language, it's ambiguous, meaning the terms of your language are unclear, and therefore can result in complicated litigation. This is why the forms that have been created for us we need to be aware of and we need to use them, because writing shorthand or not knowing which forms are out there causes misunderstandings, which causes lawsuits, which causes people to complain about the cost of the lawsuit to everybody that they know, which causes somebody to tell them, you should turn that agent into the Division of Real Estate. And they call the division, and the division says, thank you very much for bringing this to our attention. Yes, this agent was wrong in making his own language. Agent, here's your fine. Go up and take some CE classes to learn how to do your job better. All right? So, happens all the time. To avoid this problem, use your forms that have been prepared for you. If there is no such form that's been prepared for you, which is pretty rare because these forms have been prepared by your state's Board of Realtors, and they cover, I mean, there's thousands of transactions that your state does. These forms are prepared to cover those contingencies. So in almost every case, there's a form ready and available for you. Okay? Here's one right here. Is it a good business practice for real estate licensees to sign documents on behalf of their clients? Now, of course, your knee-jerk reaction is going to be, no, that's silly. Why would we ever sign documents on behalf of our clients? Well, let me give you a situation. Your client's gone to China. Before he goes, he tells you, you know what, we're going to be gone for a week. We're not going to be available via email or anything, but do call us. If anything comes up, call us and let us know. And so you call him and you say, hey, we just got an offer on your property, but they've asked us to respond by tomorrow. And your client says to you, you know what, we are interested. We like that offer. Go ahead and sign acceptance for us. And somebody in here typed in, use DocuSign or some electronic signature. Now remember, they don't have access to their email wherever they're at. They can get a phone call, but they don't have access to email. And let's say that they don't have a smartphone. Okay, they're just using a regular flip phone or something like that. So those electronic signature options are out in this scenario. And by the way, if you don't have an electronic signature program, I highly recommend getting one. They're a great tool for us. I save so much time with those. But again, that's beside the point here. If you want a recommendation of a good one, DocuSign. I use a program called iSignHere. You can look them up, iSignHere.com. But they're Utah-based, but they do a pretty good job as well, and they'll give you a discount. Well, we negotiated one for our agents, so a little bit of savings there for you. But in this case, they can't do an electronic signature, but they did tell you over the phone, go ahead and sign on our behalf. So you have their verbal permission. They're out of state. They cannot accept it any other way, so they tell you, go ahead and sign on our behalf, all right? Can you do it? If you think yes, because you have their verbal permission, click the button and raise your hand. Okay, a couple of you took my bait. I'm going to lower the hands. Even if you have verbal permission, you cannot. All right? So let's see if I've... Okay, this is a comment that I like to read because it's accurate. I would say no. Somebody should have been given power of attorney before the clients left for China. Okay, now let's talk about this really quick. The answer is no. Clear no. Doesn't matter if they give you verbal authorization or not. It's a clear no. A real estate licensee does not have the legal authority to bind his clients to a contract unless they've been given a valid written power of attorney. However, even if they have a valid power of attorney, that can cause problems and is not encouraged. And the reason why is because you're an interested party. In other words, if you sign acceptance, you're making money off of this, and that weakens the client. And so if your client gets home, even though they gave you a power of attorney to sign for them, and then they countersue you saying, look, yeah, we gave him a power of attorney, but he's abused it here just so that he could get a commission. There's no way that we would actually have agreed to this thing. Then because you've got a financial interest in this transaction, that contract could still be voidable. So in order to protect yourself, don't ever sign documents on behalf of your client, even if you get a power of attorney. So if they're going to China, have them give somebody else a power of attorney. Their neighbors, it doesn't matter. Just don't make it you, okay? Whatever you do, don't sign the purchase contract like this. Bobby Buyer by Andy Agent or Sally Seller accepted by telephone conversation. It will create problems, and it will also get you in trouble. All right, here's a great question. Love this question. Lead-based paint addendum. We have a property built in 1979. I'm the listing agent. Do I need to use the lead-based paint addendum? If you think yes, raise your hand. Built in 1979. Wow. No takers on that one. That's the first for me. Okay, the property was built in 1978. Do I need the lead-based paint addendum? Click the button to raise your hand if you think so. Usually I can trick people up on the 1979 one. That's because we start to second guess ourselves because it's been a long time since real estate school. All right, I've got some hands going up here. I'm going to lower those. Let's say the property was built not in 1978, but it was built in 1977. Now, do I need the lead-based paint addendum? Okay, very one of you caught me. This one is a trick question, and you caught me in it. So let's go ahead and discuss it. Congratulations to whoever typed in. Well, I know who it is, but I'm not going to. Oh, two of you caught me in the trick because somebody else just typed in. All right. I've been asking who needs the lead-based paint addendum. Okay. If I modified that question and asked about the lead-based paint disclosure, most of you would be right. Okay. Nearly half of you, when I asked about 1977, agreed. The contract reads, or the lead-based paint disclosure requirement, this is a federal requirement, so it doesn't matter which state you're in, but the federal requirement says prior to 1978. Now, I have seen some underwriters, especially with banks involved, they don't understand the rules, and so if the property was built in 78, they're still requiring it. That would be wrong on their part, but they're the ones giving away the money, and if they require it, you still got to give it to them. But the law says prior to 1978. So if I'm a listing agent and I have a home built in 1978, I do not need to include the lead-based paint disclosure, okay? Because the law says prior to, not including 1978. Okay, hopefully that part is clear. So all of you that answered 1977, you got it right. Nobody answered 1979, so congratulations. I think that's a first. Some of you did answer 1978. Hopefully that was able to clear that up for you. However, the question was, and only 2 people typed this in to catch me with it, but the question I was asking is, should we use the lead-based paint addendum on those dates? And the answer to all of those would be, it depends. Okay? Nobody could really answer yes or no. And in fact, in almost every case, the answer would in reality be no. Let's go over the difference between these two forms because we get this mixed up a lot, and sometimes agents think that these forms are interchangeable. They don't understand the difference. To understand the difference, it's very simple. You go in and read the forms. They're very different, and this lead-based paint addendum doesn't apply at all unless somebody requested a lead-based paint inspection. Somebody says if you used it and didn't need it, there still is no problem, and that's not entirely correct. Okay, I'll give you an example. First of all, let me do this or explain the difference between the two, and then I'll give you the example of why this can be harmful using it. First of all, lead-based paint disclosure. This is what's federally required. Any property built prior to 1978. You have to have it in every instance prior to 1978. You only need the lead-based paint addendum when somebody on the lead-based paint disclosure requested a lead-based paint test. Otherwise, everything in the lead-based paint addendum is irrelevant. Now, if you're including, so there's, as one agent typed in, if you used it and didn't need it, there still is no problem. The reason why I disagree with that is because if I'm using a form that is not required, was not requested, and is completely irrelevant, I've just confused buyers and sellers. And anytime I confuse buyers and sellers, that's dangerous. That can lead to litigation. So make sure you understand the difference between the two forms and only use them when they're appropriate. The other reason that this is dangerous is I've seen underwriters, because somebody provided a lead-based paint disclosure, even though it was checked, no, we do not want to or require a lead-based paint inspection, a lead-based paint addendum was still included. And the underwriter said, you've used a lead-based paint addendum, which of course they saw it was incorporated into the contract. Therefore, I want to see the results of your lead-based paint test. And the buyers responded and said, we didn't do a test. And the underwriter said, now I think you're lying to me and trying to hide something, because you included an addendum that only is necessary if a test was, if you're going to be doing testing. So you said you would be doing testing because you've included this addendum, even though the lead-based paint disclosure says you're not. You've added this, so I think you did, so provide it to me before I'll give you the money. So yeah, potential problems. So the question is, so if they bought a house, this is another one typed in, so if they bought a home built in 1970, would they still be confused? It doesn't matter. If it was prior to 1977, you don't use a lead-based paint addendum unless they've requested in the lead-based paint disclosure to do separate testing. And again, if you're confused about those two, make a special note today to go back and read your lead-based paint disclosure form, because there's only one part of that down at the bottom where the buyers can request a lead-based paint inspection, in which case this form is required by law. In no other case does this form need to be used. Okay? Hopefully that was clear. If not, make it a special point to go read up on this and firm up your knowledge there. Okay. All right. Oh, that was the answer. I just went over all of that. Okay, this is the last question, and we're basically out of time, so I'm going to go through it really quickly. And basically, what it is kind of this is a really contrived scenario here. What we've got is the buyer presents an offer to the seller to purchase the seller home. In the meantime, buyer number 2 also presents an offer to seller. The seller likes this, but they're going to counter it as well. So they use the multiple offer disclosure form. They counter both of them, and anyways, they go on vacation. The buyer number 1 decides to accept it, so they call, and the seller doesn't answer. They're out snorkeling in the ocean, so they leave them a voicemail. Buyer number 2 calls. The seller just happened to come out of the ocean, heard their phone ring, pick it up. Buyer number 2 says, you've got a deal, we've accepted it. Later on, they check their voicemail, and they see that buyer number 1 had also accepted it. And so what's the likely result of this? Very contrived situation, but, and if they use the right forms, they shouldn't be in trouble a lot. But this does teach us one important lesson, again, as far as acceptance goes. Acceptance occurs when 2 things have happened. It's been signed and communicated. Now, as far as legal precedent goes, communication must be direct. In other words, it's face-to-face or voice-to-voice. Voicemail is not direct. Fax is not direct. Emails are not direct. So if you're accepting something, make a special effort to call until you get the other party on the line and say, hey, we have acceptance. An interesting note to this is they don't have to have that acceptance in hand. My client could sign it, call me and say, it's signed, we'll be emailing it over to you later tonight. I can call the other party and say, it's signed, we're under contract. Even though I don't have it and I haven't gotten it into my seller's hands yet, technically we have acceptance. It has been signed and it has been communicated. That's the point where you're considered under contract. All right? So, thank you for joining me today. Here's your homework. get into this habit of studying 15 minutes a day. It doesn't matter what you're studying. If you're a newer agent or if you happen to guess wrong on a lot of these questions, I would recommend starting with your purchase contract, because all the scenarios that I gave you were based on the basic contracts. I didn't use any really weird forms out there or anything like that. So spend a little bit of time going back and rereading all the language here. Okay? Standard addenda. Go through that list of addenda provided to you by your state, by your board, and make sure that you're familiar with those terms. And then if you feel great on those things, sometimes I actually open up state law and read through that, okay, to brush up on things. But if you feel pretty good on those terms, just make general study a priority for 15 minutes a day. Buy books on tape, CDs on tape. Your knowledge base is why people hire you. You have access to knowledge. You know things that they don't. You can make the transaction easier for them. If you fail to do so and land them in court through your own lack of attention to these types of things, then you're not really providing value as a real estate agent, but you do provide yourself with a lot of liability. So take this to heart, folks. Thank you for joining me today. And for a recording or to see a copy of this again, you're welcome to subscribe to my YouTube channel. And you can review everything there. Or if you've got other agents in your offices that you think this would be valuable to, they can subscribe to it. And thank you again. Email me if you have questions or ideas for future trainings. My email is eric.lee@equityutah.com. And have a great week. We'll see you next week. Bye-bye.